Well, tonight, a new court filing is raising questions about what happened leading up to the release of a convicted murderer 16 years early.
So Jeroid Price was sentenced to 35 years behind bars for the 2002 murder of a former football player who played for UNC and USC. A former Richland County judge signed an order to release Price in December. He was released then last March. The victim's parents and prosecutors have raised a series of issues with the order.
Price's attorney argues that the early release was legal due to Price's actions, supposedly helping corrections officers, and a motion from Richland County's solicitor.
Chris Joseph is following this case and joins us in our studio. So Chris, this all centers around what constitutes a motion.
Yes, with this new filing, that's the bottom line. Now, the reduction of the sentence per state law for a prisoner significantly helping corrections officers has to come from a prosecutor. Now, Manning's order, Judge Casey Manning's order, says Solicitor Byron Gibson motioned to reduce Price's sentence. Gibson says no motion was ever filed because the order had already been signed. Now, a new filing from defense attorney Todd Rutherford claims Gibson made an oral motion in the judge's chambers to reduce the sentence. On Wednesday, the South Carolina Supreme Court will hear the case of South Carolina versus Jeroid Price. Both sides have lined up their legal arguments with conflicting stories on if Fifth Circuit Solicitor Byron Gibson motioned to have the sentence reduced. The order says he made a motion.
Solicitor Gibson said he never filed any such motion, and there is no such file in Jeroid Price's file.
In a press release, Gibson said his office was moving forward on a motion, but no motion was filed because former Richland County Judge Casey Manning had already signed the order. But a filing from defense attorney Todd Rutherford claims Gibson made an oral motion to reduce the sentence. The filing includes an email which shows Gibson saying he'd submit the final version of a proposed order for Manning the same day Manning signed the order. Gibson declined to comment on Tuesday, citing Wednesday's hearing. Rutherford was also unavailable due to the hearing, but Carl and Lily Smalls, the parents of Carl Smalls Jr., spoke to reporters.
Between all the people involved in this order, it's just too many years of law experience to do something this idiotic.
100 years.
100 years to sign something like that. You know, my 14-year-old grandson would probably look at it and wouldn't get himself involved in something like this. I don't get it.
They were joined by members of the legislature, law enforcement, and prosecution who have called for judicial selection reform by stripping power from lawyer lawmakers who help shape the process. Rutherford is a lawyer lawmaker and is part of a commission which helps choose which judicial candidates the full General Assembly votes on.
They then use their influence to convince other legislators to support the candidates they want to see elected by the General Assembly. We all know that foxes guarding hen houses is a bad idea.
The Smalls gave their support to the judicial reform efforts and expressed frustration with the system.
And you know, to me, I look at it as I started looking at it as more of a criminal assistance system than a criminal justice system. And this is what we did. This is what we're doing with murderers like Jeroid Price. We're assisting them.
The Supreme Court hearing is at noon on Wednesday. Of course, tomorrow the Supreme Court will weigh a request to nullify Price's early release and bring about a warrant for his rearrest. Now, the Supreme Court traditionally streams its hearings online, but we were informed today that's not going to be the case for this hearing. We asked why, but have yet to be provided a